Welcome and thank you for joining today's web conference, the 5010 FJ Training for CDCs. Please note all audience members are currently in a listen-only mode to minimize background noise. There will be Q&A at the end of each segment. At these times, I will provide instructions on how to ask questions over the phone. You are welcome to submit written questions during the presentation, and these will be addressed during the Q&A sessions. To send a note, please use the Notes tab on the right-hand side of your screen and address your notes to all moderators. If you require any technical assistance, please either call our help desk at 888-796-6118 or send a note to the ATT CES operator via the software. At this time, I'd like to turn the call over to Linda Riley, Chief 504 Program Branch. Linda, please go ahead.
Thank you. Hello, everyone, and welcome to today's webinar. This is the second in a series of 3 webinars that we're having on SOP 5010 5J changes. The effective date of the new SOP is January 1, 2018. Our next webinar is going to be solely on corporate governance issues, and that will be on Wednesday, December 6, 2017. We tried to answer a lot of your questions on the last call, but there were some that involved a little more in-depth analysis. So what we're going to do is take today's questions and the questions from the October 23rd webinar and have a Q&A that we'll distribute to all the participants and that we'll also share in ACO after the event. So on the upcoming events and resources, we also have the 504 Connect call with lenders that is coming up December 12th. We hope that you will participate and encourage your lenders to participate. That particular webinar will basically just be about the loan process. We won't talk about corporate governance at all on that call. Also, too, there's some resources that you might need to be aware of. The CDC online tool is available, and we have updates on that as per SBA Notice 5017-11. So there's a webinar and resources that you can access. So that's the link that we've provided, and we hope that you will do so and share with your staff as well. The IRS Form 4506T, we have guidance on that, and we have the revised form available. So please be aware of that. And the SBA Franchise Directory, which Steve O'Leary talked about on last month's call, you will have a link to it, but you'll notice that there are franchise code numbers until after January. So you'll see the names of franchises listed. You won't be able to see codes until January when the new SOP becomes effective. But it's a great resource, and it helps you become familiar with where it will be located on our website in January. So please feel free to go check it out and let us know if there are questions you have about any of those. Our hot topics on today's webinar is the EPC OC deal structure, the change of ownership deal structure, environmental updates. We have historic property review. We have staff from OGC to not only talk about the environmental updates, but also, too, about the historic property review and the historic tax credits. We're also going to talk about some loan closing issues on the next slide. We'll talk about some loan closing issues as well. We have the master creditor agreement, malpractice insurance, liens, lien instruments, interim lender document recording, and designated attorney hardship waiver updates. So just so you know who our guests are from OGC today, Ian and I will be talking about the loan processing issues and some changes that we've had in loan processing. And for the environmental updates, that will be Eric Adams, and he's with the Environmental Committee with SBA. Have Bill Gary, who will be talking to us about historic property review and resources to assist CDC projects. And then Buffy Rudefell, who is the head of the 504 Closing Committee, she will be talking about the closing issues today. So let's get started. So on EPCOC, the main issue is with the new SOP is that we are incorporating the language from the regulation into the SOP. And I also have Babak Nasani, who's here with us today, too. He takes a lot of the questions. So I'm going to talk about how we gave a clarification on ineligible excess rent. And Babak is going to talk about the technical default of occupancy. And so let me start with that. In the regulation that was published, what we refer to colloquially as the catch-all reg, we explained that there was an issue with excess EPC OC rent, and we provided a clarification that the CDC would need to provide amended or executed leases if the EPC OC rent was excessive. And now I'm going to turn it over to Babak, and he's going to talk to you about issues that we had seen with technical default, and hopefully even the slide after that about how we've issued clarifications to prevent issues. So Babak?
So about the technical default for ineligible excess rent, some of the examples that we've had was the applicant is coming back to get a second loan from the same CDC, and when the servicing center ends up pulling the previous loan that was funded for the same borrower, we noticed that the OC was paying the EPC in excess of $800,000, of rent on an annual basis. And that was an issue because, of course, it's an excess rent, and so the borrower would not be eligible for another 504 loan until that's actually remedied. And that was our workaround. Previous to the remedy, the borrower was just not eligible for any other financing period. But through working with our attorneys and with Linda, we were able to provide assistance to our borrowers that as long as they correct the EPC OC lease and the rents are no longer in excess, then now the borrower would be eligible. And what the CDC needs to do is get that fully executed new lease, submit that over to Sacramento along with the application, and Sacramento will go ahead and approve them. Some of the examples that we've had that rents were allowed or slightly excess rents are allowed would be if the borrower is, an example would be monthly rents are $5,000 and the OC is paying $5,200 a month. That extra $200, as long as the CDC can validate and provide documentation that extra $200 was to go into, it's going into the balance sheet. You can see it on the balance sheet. It's to provide maintenance to the building. That's something acceptable. But when the $5,000 is doubled and it's $10,000, that's something that SBA is looking at being in excess of rents.
So the clarification that we provided in the SOP is to explain that the rent and lease cannot exceed the amount necessary to make the loan payment to the SBA and the third-party lender, and an additional amount to cover the EPC's direct expenses of holding the property, such as routine maintenance, insurance, and property taxes. Lease payments cannot be included to accelerate payments on the third-party loan. So we're hoping that by having this clarification not only in the regulation but now also included in the SOP, that this will provide clarification for CDCs on what they need to look at when they're looking at EPC-OC rent. But in addition to that, we would ask that the CDCs not only communicate this to the borrower during the application stage, but you would also communicate it to them at closing. We know that some CDCs have had their CPAs tell them that they should charge higher rent than we would normally allow, and if the CPA is unaware of our requirements, they wouldn't know. And so we ask that the CDC provide the borrower at closing, if there's an EPC-OC involved in the deal, some documentation at closing to give to their CPA. So next slide, please. So Bobak's going to go over some examples of acceptable, not acceptable EPCOT deal structures.
So what we have here is DOC is paying excess rent of $220,000 using those funds to purchase other property for the EPC. OC is paying the excess rent in the amount of $75,000 to amortize the first mortgage faster. OC is paying excess rent to make payments on additional financing obtained on the subject property, and excess rents that are acceptable. The only acceptable solution to the existing excess rent is to submit an amended lease that clearly reflects that no excess rent will be paid. And I did see a question that popped up was that previously CDC thought that this amended lease had to be recorded. That's no longer...
It's jurisdictional. It depends on the jurisdiction.
Okay, so on the jurisdiction of where the property is located. The next one would be technical defaults that are not acceptable. Is existing 504 finance project is currently leased at 80% to an unrelated third-party tenant when applicant applies for a new 504. The acceptable version would be OC currently occupies 100% of the existing 504 project and needs to expand. They will occupy 100% of the new property and will maintain eligible occupancy level at the existing facility.
Next slide,
please. So one of the examples that we have for change of ownership, in this example that I have is we have two owners, one at 10%, one at 90%. The 10% owner wants to own 100% of the entities owning the eligible fixed asset. The rest of the example goes on for purchase contract of $900,000. The 90% owner's interest in the entity that owns $1 million building owned free and clear. Purchaser can use their equity towards the injection but cannot receive any of the project funds. Structure could look like as follows, basically. The TPL would be at $500,000, the SBA portion is at $400,000, and the borrower's equity, which is in the property, is at $100,000. This would be an acceptable case in terms of change of ownership. However, the CDC still has to provide documentation and elaborate in the credit memorandum that the owner that is selling their portion was not a managing owner, and it won't be affected. Basically, we would have to look at the new business definition of will it even affect that or not. So we would have to look to see if it's an unproven, will it change the management structure, and will it increase in any kind of debt? And in this case, this doesn't seem like that would follow that example. Next slide.
Well, I think next slides are Ian and I providing an update on some of the others. Now, we did have some questions that came in during Bobak's discussion. I would like to hold those questions because we're going to be here for the duration of the webinar. We do have some other presenters that have smaller segments, so I would like to hold the questions for the OFA team to the end. So we'd like to go ahead and talk about, Ian and I would like to talk about the updates on businesses engaged in illegal activities and the other topics on this slide. Businesses that are engaged in illegal activity have always been prohibited from receiving 504 financing, but there was some ambiguity of whether or not, or borrowers said, well, we didn't know, we couldn't rent certain space as long as I'm the eligible business and I'm allowed. We didn't know that our tenant had to also be 504 eligible. And we have a clarification from the Office of General Counsel that if there's any illegal activity, not only with the business, but for any of their tenants, then that leaves the entire property subject to seizure. So that's a risk that SBA is not willing to take. And so we do provide clarification in the SOP on those businesses that are engaged in illegal activity. The most common question that comes up is, what if it's legal in one state but not in all states. Since we are a federal program, we are subject to federal requirements on what is legal and what is. So if it's not legal at the federal level and in all 50 states in our territories, then it's not eligible for 504, and you can't lease to that type of tenant. The religious eligibility checklist is new. It's for 1971, and the Office of General Counsel has to make a determination whenever a business is engaging in an activity that raises the question, is the business actually a part of a religious group, or is there a secular nature to the business so that it's still eligible? An example of this might be a bookstore. If a small portion of a bookstore happens to sell religious books, well, that would normally be eligible, but it's not automatically that the CDC can make that determination. The CDC would have to submit an eligibility checklist, and then they would submit that to the SLPC. SLPC has local district council review it. If local district council can make the determination, then they respond to the SLPC. If local district council needs assistance, then they'll forward the questions to OGC at headquarters, and then OGC at headquarters will make the final determination. So I think the having this checked out with council is not new. I think what's new for most CDCs is the Form 1971, and we also recommend very strongly that you address this fully in your credit memorandum, so that if the Office of General Counsel needs to see the form and they ask for the credit memorandum, that you fully address any issues. So, Ian, if you don't mind, you did such a great job at the conferences on talking about eligibility and CABRs and prior laws. If you would, could you share with everyone on the webinar what you shared at NATCO?
Yes. This is Ian from SLPC. For updates on non-U.S. citizen eligibility, one of the eligibility of loans to businesses owned by non-U.S. citizens remain the same. The new SOP now provides significantly more information and guidance on the forms and documentation that the CDC may encounter. Please be reminded that the CDCs must still continue to submit requests for document verification to the center. And, of course, please refer to the SOP for more details and what is necessary to provide, and also email addresses for the service that you need to see in the SOP. For CABRs and prior lawsuit government updates, it is the responsibility of the CDC to check for a credit alert verification report system, aka CABRs, as the SOP now gives a link to the site. And the CDC may request a waiver for the delinquent debts and the prior loss, and that is the change in the SOP to allow the CDC to submit such requests using the pre-application method. Now, please also note that the waiver for delinquent debts decision will be made by the Chief Financial Officer, while the decision on prior lawsuit government waiver request will be considered by the Director of the Office of Financial Assistance. So that's basically the update on those three items. Thank you.
So now we'd like to have Eric Adams give us more detail on the environmental updates in SOP 5010-5J. Eric?
Thank you, Linda. Hello, everyone. One of the most significant changes that we made to the environmental policies and procedures of the SOP is that effective January 1st, the SBA will accept Phase 1 reports that are up to 1 year old. By allowing for a longer shelf life for Phase 1s, we expect the loan cost to borrowers will in many instances be reduced. That's because the SBA won't be requiring that reports over 180 days be updated. The cost of those updates were historically borne by borrowers, and in some instances even by CDCs when they realized that it was going to cost more for the borrower to have to pay for yet another report. So this should be good news for everybody. Another benefit of this change is that it will reduce the number of SLPC screenouts based upon stale Phase 1 reports, and will also reduce the number of appeals to the SBA Environmental Committee to accept outdated reports. So this should improve turnaround times for SLPC review and approval of these reports. It's important to note that although SBA is accepting Phase 1 reports that are up to a year old based upon SBA's risk tolerance, I want to point out that borrowers and other parties to a transaction may still wish to comply with the Environmental Protection Agency's regulatory guidelines. And that's because purchasers of real property that don't comply with EPA's guidelines for Phase 1 reports may not be able to avail themselves of legal and regulatory protections, such as the innocent landholder and bona fide purchaser defenses. So as you see on the next arrow there, another significant change that was made is in the area of no further action and closure letters. This change was made because in some jurisdictions, the state government isn't responsible for issuing NFA and closure letters. Rather, those states have delegated that authority and responsibility to licensed environmental professionals. SBA now recognizes those state equivalent NFA and closure letters. I want to point out that this is primarily an East Coast phenomena, so it should make it easier for getting environmental clearances from the SBA for loans that are in the states of New Jersey, Ohio, Connecticut, and possibly Massachusetts. Massachusetts is a little different. That state uses licensed site professionals that can issue something called a response action outcome, which the SBA can sometimes accept as a no further action letter depending upon the circumstances. Next slide, please. So another significant change that was made is the new requirement that CDCs not enter into any agreements that alter the terms of SBA's template reliance letter. We believe this change was necessary because we learned that some CDCs had entered into service contracts with environmental firms, not realizing that some of these agreements contain language that specifically altered the terms of future future reliance letters. I want to stress that this was unintentional on the part of our CDCs. However, in order to keep this from happening in the future, SBA added this language to ensure that CDCs carefully review all agreements that they enter into with environmental firms to ensure that they're not agreeing to anything that could alter the SBA's or CDC's rights under the SBA's template reliance letter. We also added language to the template reliance letter waiving time limits on liability. So as you can see from the slide, we did this because we discovered that one very large environmental firm was including a 180-day limitation on liability in the terms and conditions section of their environmental reports. So as you might expect, environmental issues often don't come to light until years later, usually when a lender is getting ready to foreclose on a property. And then they order an environmental assessment from a different firm, and that's when they discover there was a problem. Next slide, please. So another change that we made was the elimination of what I'll call fuzzy language in the SOP. That was language that triggered a Phase 2 in the situation where a dry cleaning facility was in operation for more than 5 years. And the language was worded in such a way that it really wasn't clear what 5-year period we were referring to. And so when we reached out to a number of environmental professionals, in-house and outside, we learned that we weren't really in line with industry practice. So we modified that section so that we're now in line. So we now require a Phase 2 for any property with on-site dry cleaners, whether currently in operation or operated historically at the site, that did, do, or likely used chlorinated and or petroleum-based solvents, in addition to a Phase 1 which would be required due to the mixed good match. And dry cleaners are particularly risky. If you didn't know it, a few drops of TC, perc can contaminate an entire water well. So we also made a minor change to the gas station section in Appendix 5. We specifically stated that Phase 1 reports for gas station loans have to include the documentation that support the environmental professional's determination of compliance with regulatory requirements, if any, pertaining to gas station tank and equipment testing. And the reason we did this is because this documentation was often absent from environmental reports, causing delays in SBA's review of these reports. So by setting forth this requirement in the SOP, we expect the number of environmental screenouts for gas station loans will be reduced. Next slide, please. So record search with risk assessments. For those of you that don't know this, the record search with risk assessment is actually a product of SBA's creation. And because the government is so fond of acronyms, we call it an RSRA. As you probably do know, RSRAs have a requirement that an environmental professional review historical records for a property as part of the risk assessment. So as of January 1st, there will now be a look-back date that effectively brings the historical component of RSRAs in line with the historical component of other environmental reports that are recognized by the industry, specifically transaction screens and phase ones. So this change to the lookout period of 1940 or the first developed use, whichever was earlier, will ensure that future RSRAs that are provided to CDCs and SBAs are more reliable because the underlying historical data within each RSRA will be more reliable. Finally, we stated in the SOP that the historical records relied upon professional have to be included with each RSRA, which should also increase turnaround times because a lot of times this information was lacking from the RSRAs, and our environmental engineers in the Sacramento Processing Center had to reach back to the CDCs and ask for that information to be included. On the template reliance letter, on the next arrow there, you'll see, we made a change that for the purposes of the letter, for the template reliance letter, the CDC is the lender. And we made this clarification to reduce screenouts as we found that some CDCs were inserting the name of the third-party lender at the top of the letter rather than inserting the name of the CDC, which has always been a requirement. Another change that we made to the template reliance letter is that on page 1, where the environmental professional identifies a specific environmental investigation that they performed. We learned over the years that addendums are sometimes made to phase 1 reports, and the existing language in the reliance letter didn't cover addendums. As you know, unless the addendums were specifically referenced in the reliance letter, SBA cannot legally rely upon them. So by including the addendums to the phase 1 report in the original letter, we'll be able to rely upon the addendums without having to go back and asking the CDC to get the letter modified. So as I previously discussed, we also modified the letter so that environmental professionals also now waive time limits on liability. I want to point out that it's really important that CDCs notify their outside environmental professionals that this new template reliance letter has to be used effective January 1st. So if your CDC obtains environmental reports from third-party lenders, also please let your TPLs know about this change. We were recently asked if the new letter can be used now, and the answer is yes. In fact, we think it would be a really good idea to start using the letter immediately. Next slide, please. So we added a new paragraph that addresses the issue of third-party rights to environmental identification from CDCs and SBAs. This paragraph is actually designed to protect both the SBA and CDCs from lawsuits, which can occur if SBA or CDC forecloses on a property where these covenants run with the land. So by putting this paragraph in the environmental section of the SOP, we hope to increase awareness of the issue of environmental identification as opposed to other identification provisions running with the land, which, as you know, were addressed in SBA procedural notice, I think it's 5,1337. Those are fine. It's the environmental ones that are particularly risky to the agency, so those go to council for review. Increased awareness of this issue is really critical because we want to be able to spot it early on and resolve it before the borrower acquires title of the property, because often that's the only time these issues can be resolved. None of us want to find ourselves in a situation where a third-party lender and an interim loan have already funded, and then we find that the SBA can't take the interim loan out due to potential environmental liability. Because as we all know, once a seller is part of the title of the property, there's absolutely no incentive whatsoever for them to remove rights to identification. And at that point, we just can't get them to do it. But they have every incentive to do it while they're still trying to sell the property. Next slide, please. Okay, so turning to mitigating factors for disbursement in the presence of contamination. We made a very minor change to the title of one of the mitigating factors. At the very top, it used to read minimal contamination, and we changed it to more accurately reflect the requirements of that factor. So we just added that language that you see in italics. We also made a change to other factors for disbursement in the presence of contamination to clarify when the existence of environmental insurance is persuasive to the SBA Environmental Committee when we're considering it as a mitigating factor. We used to just say environmental insurance. Now we say environmental insurance that is already in place and already paying remediation costs, because that's really when it's important. We also added brownfield agreements as an example of a mitigating factor that could be considered. I want everyone to keep in mind that when you're seeking exceptions to the agency's environmental policies and procedures, those go directly to the SBA Environmental Committee at the email address that you see on the screen. And we already discussed the change to the no further action mitigating factor. So next slide, please. So we made some changes to the NAICS codes of environmentally sensitive industries in Appendix 4 that trigger an automatic Phase 1. We added the NAICS code for trucking, but only in those situations where there are service bays, truck washing, or fuel tanks present. That, frankly, should have been in there from day one. I don't know how that was omitted, but it was, so it's been put in there. We also added a NAICS code for indoor and outdoor shooting ranges. This was done because there are significant environmental issues related to both lead dust and lead at shooting ranges. There have been a number of gun clubs and shooting ranges that have been targeted for environmental lawsuits. Also, the EPA issued some guidelines recently with best management practices for lead at outdoor shooting ranges. So if you've been following the media reports, there's been a lot of articles about facilities that are, these facilities are particularly challenging to lenders, which in turn increases demand on the SBA loan program. So I want to point out that also a phase one is a requirement when you have indoor and outdoor shooting ranges. In a lot of cases, this is just a starting point for the environmental investigation, and that is because sometimes, or a lot of times, environmental reports on shooting ranges will actually make additional recommendations, such as imposing a site maintenance plan that would be implemented to reduce environmental risk to people, property, and the environment. So those will fall in housekeeping measures, and so they generally have to be complied with before we can go ahead and fund a loan. And let's go to the next slide, please, because we already covered the gas stations. We also tweaked NAICS codes that you see on the screen. So the language that you see in italics on each of those 4 NAICS codes is new. We expect that these changes will reduce the number of phase 1 reports that are required under the SOP. That is because we've clarified that in certain circumstances, these particular industries, these industries will not engage, are not engaging in the type of activities that would trigger a phase 1. And then at the very bottom, you'll see 8122, and for those of you that are wondering, because I used to wonder at a time, death care services actually refers to funeral homes and related businesses. Slide, please. Okay, and finally, because some folks like flowcharts, we have a flowchart that covers the environmental investigation process for SBA loans. This is, of course, a general overview of the process. You should be guided by the specifics of the SOP, but for those folks that would like to see it, that's the review process all laid out. And before I turn this over to the next speaker, are there any questions about the changes to the environmental portion of the SOP?
Well, we had one question, Eric, come in, and then those of you who would like to raise your hand so that they can open the lines, please do so. One of the questions that we've had, Eric, is does the 1-year shelf list also apply to RSRAs and desktops?
Well, it has always applied to RSRAs. So the 1-year shelf life is, they're all in line now. So phase 1s, RSRAs, and transaction screens, we allow them up to 1 year old. Beyond that, they have to be updated. With phase 1s, it's a little harder to update. We don't have a shelf life on phase 2s because, in general, those are good for a long time. And then you asked about desktops. A desktop is not a recognized environmental investigation that SBA recognizes. We only recognize environmental questionnaires, RSRAs, transaction screens, phase 1s, and phase 2s. So if you're getting a report from an environmental engineer or environmental firm that's called a desktop, you'll want to go back and look at that report very carefully to make sure that it meets the definition of one of those, like probably an RSRA. But you want to make sure that they say that it complies with SBA's requirements for record search and risk assessment.
Thanks, Eric. I did see a question, did we have a link to the new Reliance letter? We don't in the PowerPoint, but it's one of the appendices in the SOP, so you have copies available to you in the SOP itself. I believe also that NADCO has extracted the appendix from the SOP and has a version of that on their website if you want to contact NADCO or visit their website. NADCO has excellent resources, so we always appreciate their help. So do we have any callers? Do we have any call-in questions?
If you wish to ask a question, please dial #2 to enter the question queue. You'll hear a notification when your line is unmuted. At this time, please state your name and question. Again, that is #2 to enter the question queue.
And for this segment, please ask only environmental questions. We'll get to other questions later in the segment. Any environmental questions for Eric?
If you think of any in the future, feel free to reach out to me individually, or you can reach out to environmentalappeals@sba.gov, and we'd be happy to answer them.
Eric, and all of our presenters' emails will be on the very last slide of the presentation, and so you'll have access to everyone's contact information. If there's something we can't answer in the limited time we have today, we certainly would like to do that. So any callers in the queue?
At this time, we have no callers.
Okay, Eric, they say that that's a remark of a really great presentation, that there were no questions. So we'd like to move on now to talking about historic property review, and I'd like to introduce Bill Gary. Bill Gary is with the Office of General Counsel. He has been a tremendous resource to us in the Office of Financial Assistance. Very prompt and responsive and highly knowledgeable. He has a great working relationship with the National Trust and the National Park Service, and he is very committed not only to helping be responsive to your state historic preservation officers, but he's also been very responsive in assisting borrowers. So now I'd like to turn it over to Bill Gary.
Well, I want to thank you for that very kind introduction, but I'm a little concerned that if I get a lot of questions, it's going to reflect on how good my presentation is here, so you put me on the spot.
Well, I promise you, Bill's topic is maybe one that's better gone more into detail offline. He's just trying to give the SOP update today.
Yeah, and I do want to thank everyone on the line for the cooperation with us here at the agency over the last few years, as SBA has become a little more diligent in identifying and trying to monitor effects on historic properties. And in this process, most recently we've updated the SOP, so I just want to read through that, and I have a couple comments as I go. So, Section 106 of the National Historic Preservation Act does require federal agencies to have a review process when any federally funded projects potentially impact sites that are listed on the National Register of Historic Places or are eligible to be on that register. So if a loan that the CDC in this case is going to do would have any effect, or it would be concerning a property that is either on the register or eligible, then you're going to have to consult with the local SBA council for further guidance as how the process is going to go. They then have to come to me for a sign-off in the end. So the first one you want to watch out for is if you have a situation where we're just buying a property, and there's no potential to cause any effect on the property. We're just the proceeds of the loan are going to be to purchase the property and nothing more. Then this is a rather quick process, and the local council could approve that without any further Section 106 review, and they would just send me an email, and I would concur with that, and you can move forward with that. If, on the other hand, the SBA local council determines that there's going to be something done to the property that's going to have some potential to cause an effect on the historic property, adverse or not, if there's going to be an effect to the historic nature of the property, then it goes a step further, and SBA is required to consult with the relevant State Historic Preservation Officer, or SHPO as they're called, to determine if the use of the proceeds of the loan is going to have an adverse effect on the property. If SBA looks at it and sees no adverse effect, there's going to be some minor interior changes, nothing to the exterior, bringing the HVAC portion of the property up to date, something like that. Then SBA would send a letter to the SHPO consulting with them and saying SBA finds no adverse effect, and the SHPO has 30 days to either agree or disagree with that. That 30-day time period, if SBA doesn't hear back from the SHPO in 30 days, SBA is allowed to go forward with its no adverse effect position, but that 30 days starts from when the State Historic Preservation Officer actually receives the consultation for SBA, not when the CDC has contacted SBA. And you have to keep in mind that if you're tracking that, then you have to know when that letter went out from SBA to the SHPO, and it may take some time for SBA to do the review to find out whether or not it's going to affect the property. And depending on the type of review, this may also result in, I'm jumping ahead of myself there. Okay. If SBA finds an adverse effect as opposed to no adverse effect, and consults with the SHPO regarding the no adverse effect, then in order for the loan to move forward, SBA and the State Historic Preservation Officer are going to have to agree on what would have to be done to mitigate the effect of historic property and enter into a memorandum of agreement. This type of review might require a little more time also because once we get to that point, SBA may have to consult not only with the State Historic Preservation Officer, but with local historic agencies and any relevant Native American tribes that could that the property would be in their area. I've seen instances recently while I've been working on this where CDCs are contacting the SHPO themselves prior to consulting or bringing the issue forward to SBA, and I've actually seen this work where the SHPO has then sent a letter of no adverse effect to the CDC, who then presents it to SBA. And while that saves a lot of time, when that happens, it's taking a bit of a risk because that's not the way the process is supposed to go statutorily. It really is supposed to be that SBA consults with the State Historic Preservation Officer, and if you do that, you may find the State Historic Preservation Officer getting annoyed and the process will slow down, which is not what we want. Also, there's been instances, I'm the designee who signs off in the end, and my name's involved in this, but you should always consult with your local SBA council. They will have a better understanding of the area and also maybe a better relationship with the State Historic Preservation Officer. Some CDs have reached out to me initially, and I usually will direct them to the local council. If the local district council has an issue and they want to call me or get me involved, I'm always happy to help, and at that point anyone can call me. I'll work with the borrower, I'll work with their architect, I'll work with CDC. I'm fine with that. And in the second slide of ours, there are resources. We often get questions as to how do I know if it's a historic property or not? How are you supposed to figure that out? The easier ones are the ones that are on the National Register of Historic Places. That's online. You can look those up. If not, it's going to take a little more due diligence, and we could help you with that too. If you suspect it, you could call the local council, or they can consult with me. Is it in a historic area? Is it how old is it? What was the function of the property? We can piece that together and work with you and then with the State Historic Preservation Officer to decide whether or not it is eligible before we get moving on the loan, and then you don't want this to get stopped in the middle because suddenly someone notices that. And for now, that's all I have, and I'll be happy to take any questions.
So we got one question. Can a CDC speed up the process by obtaining a letter from the SHPO before sending the request to SBA?
I think I touched on that. That's not the way it's supposed to work, and that's not the way the law is set, and it really has to be SBA doing it. If you do that, and I've seen it where, like I said before, I've seen it where the CDC has done that, they get the letter from the State Historic Preservation Officer and everything's fine. I think if Eric's still on the line, he might back me up on this. But, there are some SHPOs who would be greatly offended by that.
Yes, Bill, I am still on the line, and yes, I can attest that if that were tried in California, the result would be very negative. One CDC did that, and I got a very nasty Graham email from the SHPO in California. So at least in California, you don't want to do that.
Right, and what you need to understand is each State Historic Preservation Office is different. The way we submit things to them is different. They have their own rules and their own regulations. Some require everything in paper. Some require things submitted only online. So it's better if you can help your local council. If you want to assist them in getting the letter together or getting it moving, that's fine. You sending it in, if you've had the experience that it works, I don't want to say never do that because obviously that would save us time, but it's not the way the law is written, and it's not the way it's supposed to be done. We need to work together on this, and I think if you get a relationship going with your local council, how you guys can work this faster or get the letter out quicker, that would be the way to do it, because if the letter comes from SBA, even if you're helping them with it, it's going to get a better response.
Thank you.
Yeah.
There was another question. How does the process change if renovations are involved?
If renovations are involved, this is now it's a judgment call. It depends on what the renovations are. If we could look at this and say it's a renovation, it's an interior renovation, but it's not changing, let's say that the building itself, the real historic nature of it is the exterior, and that the interior has already been changed into offices years ago, and they're just going to update that. It's a different office coming. Or it used to be a restaurant, and now it's going to be a different restaurant. So the interior is going to be renovated, but it's really not altering anything that was in the historic nature of the property because it's really the exterior at this point. Then the renovations wouldn't be a problem. If you're dealing with a building that's historic not only outside but inside, based on its, I don't know, I'm trying to think of an example off the top of my head, but if you had an older house, a Victorian house, and you were and it was going to be offices, but you were actually changing the interior structure of it, and that was part of the historic nature of the building based on the architect or the design, then that would be an adverse change, and we'd have to somehow mitigate that.
Also, too, Bill, we had a lot of questions on what are the National Park Service's guidelines. And then taking the time to describe that really goes beyond the time we have today, but we just want to give all of our participants the links for assessing potentially historic properties, as well as for those properties that are already listed on the National Register, what are some adaptive renovations that are allowed or restricted, the very things that Bill was talking about, how to have a checklist on things to look for in the property or project that you're working on.
I think we also have a couple examples of letters.
So Bill or Buffy, do you want to talk about the example letters? I know we have Buffy who's with District Council, and she also works at the local level with CDCs in her community who have to work on these types of letters, and then obviously Bill receives all this documentation. Who would like to talk about the examples?
The examples of what letters? I'm sorry.
The letter from the State Historic Preservation Authority.
So I gave Linda a couple of redacted letters of ones that we had and approved before.
Okay. Was this a letter from the SHPO themselves to you?
From the SHPO, yes.
Okay. Well, I didn't, but you can talk about those. That's fine.
The first one, the one that's on the screen now, was for a proposed renovation of a building, and that building wasn't on the National Register itself, but it was in what was known as the Downtown Historic District, and they approved the proposed changes to that, and just underlined what was important, that they determined that the work done with the loan wouldn't affect the historic district, and that they made the comments pursuant to Section 106 of the Historic Preservation Act. And then in this letter, this was an interesting one. Somebody else had already wrecked this building, and so basically when our borrowers came in, they said that while it's on the National Register, the proposed renovations will not affect the property because all the architectural elements had already been removed from the interior. So I just thought that was an interesting and different example.
And that reminds me of something you should be aware of too. If you think you have a situation where, the SBA, you're buying a property but you're also renovating the property, but you think, well, we want to tear part of it down, but that would interfere. Then we get involved with this SHPO letter. What we'll do is we'll have a loan with SBA that just buys the property, then will do a separate piece somewhere else to do the renovations. That's not going to fly. If we find out that you're buying the building but you intend to do renovations, or tear any part down, we can't make our loan then. But that's called anticipatory demolition, I think. And you can't try to get around the law by using federal funds just to buy it, but other funds to tear it down or make renovations that wouldn't normally be allowed.
And how would they know would be your question, and the State Historic Preservation Office would then come back to SBA, and then we would potentially have a loan in default. So the best thing to do is to work with Bill and his team and with all the local district councils to make sure we have all proper clearances before we proceed.
And I know some of these take a little longer than you like, and I do understand that there's deadlines, and we do try to meet them as best we can. Sometimes, things take longer than they should sometimes, but we really do work hard on these, and we really want to make sure they get through.
We actually did just get a question, Bill, asking what sort of time estimate you might recommend providing to potential clients that involve historic properties, if there is any kind of range you could give. Might depend case by case.
Yeah, it is case by case. I mean, if it's something simple, and it's something SBA, if it's obviously if there's no renovations and we're just buying the property, that's not going to take any time at all. That is going to be a 1 or 2 day turnaround. Any renovations, if you see them coming, I would allow at least like 60 days, because you may not hear back from the State Historic Preservation Officer for the full 30 days, so it would take SBA a week or two to get out their review, so you want to make sure you give yourself good lead time on that. If it turns out a situation where it's going to be an adverse effect and SBA is going to have to do some sort of mitigation and work out a plan with the State Historic Preservation Officer, that's going to take 2-3 months.
Thanks. So next, well, we have one more question. How is it determined whether a property is eligible to be included on the register? Rather than have Bill respond to that, I would refer you back to the link that we provided on the nomination process, because they do provide guidance on what the criterion is and what the process is.
And just to inject, for those of you that are asking, yes, as always, you will get a copy of these slides after the presentation. They will be sent out, and they will later be posted, distributed, sent to the district offices, posted on NADCO's website. You will receive a copy of these slides, and those links will be included.
Thanks, Jen. So now, before I introduce Buffy, I just want to mention the fact that there are some CDCs who have been very successful in working with individual historic properties as well as historic districts. And although the clearance process, as Bill has described it, it is a necessary part of the program, there can also be benefits to that receive historic designation, or if they are eligible for historic rehabilitation tax credits. And so we have had TDCs contact us on an individual basis, and we've worked with them. And we feel that the best thing to do is to share the information with all TDCs through our SOP, so that you are aware that this is a potential opportunity for your borrower. And the person who's worked most closely with me on this is Buffy Rudisell, and she's going to give you an overview of the historic tax credits and give you a little more discussion of the mechanics of what would be required to help your borrower be able to monetize the tax credit and count it toward their equity injection. Buffy, are you on?
Sorry, I was talking to the mute button. Questions have arisen around the country regarding historic rehabilitation tax credits. And we've been looking into them up until this time on a case-by-case basis. So that's why we decided to draft language and put it in the SOP so that everyone would have the guidance. We're happy to be able to do that, because these tax credits can really provide a considerable benefit to our borrowers. But the IRS requires that the holder of the tax credits either own or lease the property. What we've generally seen is a lease of the property. So, as I've said, the SBA can participate in these, but we've listed the conditions under which we have to do them. The borrower is going to lease the property to the tax credit investor, who is going to turn right around and sublease it back to our borrower. And the terms of the lease and the sublease have to be equal. For that reason and a few others, you need to submit copies of the lease and the sublease with your 504 application. And Sacramento will submit them to the District Council for review prior to closing, because we don't want any surprises coming up at closing. One of the problems is our lien on the property cannot be subordinate to the lease between the borrower and the tax credit investor. So if you're going to do this, you need to make sure that your deed of trust or your mortgage is recorded prior to the lease. Because we have a lease-back situation, you cannot structure these as EPCOC loans. As I'm sure a lot of you have heard for years, EPCOC is an exception to the rule that we can't have a passive business. So to have an EPC who leases the property first to the tax credit investor, who then leases it back to the operating company, is just something that SBA felt we could not allow. Sometimes the structure of the transactions vary. I've seen them in different states, and there is some variety to them. So we ask that you first consult with your district council if you need additional guidance. We also have participated in projects where you have state rehabilitation tax credits. And as long as the projects satisfy these requirements and whatever the requirements are that the state has, you can move forward with it. On the next slide is an example of how these work. So a borrower may be buying a historic building certified on the historic registry for $1 million, and they're going to invest another $1 million in rehabilitating the structure. For this rehabilitation, the borrower can get a tax credit of 20% or $200,000 in this example. So the borrower can turn around and sell the tax credits to a tax credit investor by agreeing it to lease the property to that party, and then IRS will treat the person to whom they lease it as the party who incurred the cost of the rehabilitation, and they can take advantage of that tax credit. We've seen all kinds of entities taking advantage of this. We've seen banks, we've seen investment funds, and a lot of different kinds of entities. But what it means is money in the borrower's pocket. So the next slide is just a graphic. So you've got your project property, you record the deed of trust, then the property may be leased and then subleased back to the borrower. Any questions on historic rehabilitation tax credits?
Please take a moment if you have a question and send that in to us by either written question or raise your hand in the queue so that we can recognize you.
And Lauren, I'm sorry we didn't do this earlier. Can you provide the instructions for the participants to ask verbal questions?
Absolutely. If you wish to ask a question over the phone, please dial #2 to enter the question queue. You will hear a notification when your lines are unmuted. At this time, state your name and question. Again, that is #2 to enter the question queue.
And please, during this segment, only ask questions to either Bill Gary or Buffy Rudafell on historic property review or historic rehabilitation tax credit.
Well, you want me to go on then? So,
yes, please.
Okay. The next few slides are sort of a hodgepodge of issues, some of which have arisen through questions that came through district council around the country, and others that arose from observations from the complete file review that the review team has done. This first one involves intercreditor agreements. We found that sometimes CDCs are entering into intercreditor agreements with the third-party lender other than the third-party lender agreement without notifying SBA or getting SBA's prior written consent. So we put the language in the SOP to remind you that the third-party lender agreement is really the only intercreditor agreement you should be signing with the third-party lender unless you have that prior written consent from SBA. One of the things we don't want to do is have a situation where perhaps some of the provisions of the third-party lender agreement are contradicted or even invalidated by another agreement you may enter into with the lender. Next slide.
Okay, we got a couple questions on the tax credits. Do you want to take those now, or?
I'll be happy. Yeah.
Okay. So there was one question, is there a difference between state and national tax credits?
There may be, and that's why I said we have to look at the state ones on a case-by-case basis, but we can do those as well as long as they meet the requirements that we've outlined in the SOP.
Okay, if the mortgage or deed of trust isn't recorded first, can the CDC obtain a subordination agreement for the lease and sublease?
They could obtain a subordination agreement, but we really prefer that they be recorded first to avoid any issues that might arise.
Okay. If the borrower is going to take advantage of the tax credits themselves and not sell them, is the EPC-OC structure permitted?
Yes.
Okay. And how does this work with the maximum 50% from federal sources?
Well, since it's a tax credit, it's not considered to be a federal source. It's the borrower's money in essence, so it's not affected by that.
Okay, great. All right, I'll continue on to the next slide for you.
Okay.
Question.
We've looked at a number of loans where we had, for example, doctors or lawyers and no evidence of malpractice insurance, whereas they would be required to have that to practice. So that was previously one of the optional insurance types of insurance in the SOP, and so now we're saying you have to require it if it's required by state law. Next slide. Lien position on real estate is generally evidenced by the title insurance policy. And we've noticed on title insurance policies there are two kinds of arbitration clauses. One is a clause allowing either party to demand arbitration in the case of a dispute, and the other requires that both parties agree if there's arbitration. So if the title insurance allows either party to demand arbitration, then you have to get an endorsement deleting that condition. But the other requirement is fine. We found that was being handled differently in different parts of the country, and that's one of our goals is to have consistency nationwide. So this will be the rule as of January 1. Next slide. We also noticed that in a number of cases, CDCs were using the old SBA Form 928 and 930 for the mortgage or deed of trust. They don't have a due on sale clause. They refer to outdated CFR sites. And so we're putting in a requirement that you not use those and reminding you that you can use your own forms or for the lien instruments as long as they're either state bar approved forms or they've been approved by your SBA counsel prior to submission. And we started that back in 2007, but we've still seen a number of these in the reviews we've done. Next. Finally, we put this in the SOP almost more as an attempt to help the CDCs. We're asking that you ensure that all recorded interim loan documents are canceled of record within 90 days after funding, because we oftentimes, the CDCs do have the canceled documents, but in some cases where you don't, The reason is just because the lender hasn't gotten it to you and they've been dragging their feet. So we put it in the SOP and hope that you can point that out to the lender and say we've got to have it within 90 days. So that's why we added that. And I believe, oh no, one other thing, designated attorneys. We've revised the language on designated attorneys just a bit, particularly as relates to the hardship waivers for professional malpractice insurance. We've allowed those who are in small firms or sole practitioners to get a waiver to have policy limit reductions, and we're still doing that. We may also waive the deductible requirement to larger firms if they can show us a strong financial history, and that is to show us some sort of evidence of a strong financial history, not just sending in a letter saying, you know, we've been in business a long time and I assure you we're strong. They're going to have to show us some financials. But when we're looking at a waiver, we're going to be considering now not just whether you're a small firm or a sole practitioner, but we're going to look at the quality of the packages that attorney has submitted, and also the number of packages and the dollar value of those packages. And we'll just go back 12 months because we're finding in some cases where a small firm has this waiver, they're doing a lot of 504 loans with considerable exposure if there's a problem. The other thing we've done is put language in the SOP to make it clear that the hardship waiver is only good for a year, so we need to look at that each year to make the determination if we will allow it to continue. Thank you.
So we do have a few questions for our presenters today, and we have one caller. Let's go ahead and take the caller, and then we'll go back to some of the other questions.
Caller, please go ahead. Your line is now open.
There were a couple of questions. One was as to the other intercreditor agreements issue. What's the suggestion when a TPO has a security interest in property in which CDC is to take an interest senior to the TPL, for example, personal property, additional collateral?
So that ours is going to be filed ahead of theirs?
Yes.
Yeah, I mean, that would be the thing. Our lien would be filed ahead of the lender. So by operation of law, we would have a senior position. So you wouldn't need a separate agreement. If the third party lender had previously recorded their lien, you might need a subordination agreement in that case.
But if they have one security instrument, for instance, for quite a bit of personal property, some of which we're supposed to be in a senior position, and some the CDC is not taking any security interest against. And so they are of, they have, for instance, they may have a UCC, which is senior to the, or was filed prior in time to the CDC interest, and there's really just a carve-out of a portion of the security interest. Third party,
Generally, what I would do in that situation is get a subordination agreement as to the equipment or the property that's being carved out. If that doesn't work, you can enter into an intercreditor agreement, but just get it approved, you know, before closing, so that you'll know that it's acceptable. Send it through Sacramento, and they'll send it for district council review.
Okay. And one other question, going back in time to the presentation, as to the rent payment that's allowed. Sometimes in the authorization, there's other debt which is approved in the authorization, and the presentation did not indicate that rent could be charged to cover the carrying costs of that other debt. Would that be an allowable charge under the the revisions to the SOPs.
So rents that add other debts, I guess this would be a case-by-case basis, but what I've seen has been rents that have included taxes for maintenance issues. They've included those fees, but in terms of the debts of so are these debts of the OC that they're going to be adding?
It may be senior debt, but it's non-project debt that allowed to be reflected as a debt secured by the property. So maybe
no, I don't see that being an eligible. I wouldn't see that as being an eligible example. So something like that should be removed out of the EPCOC lease.
SFPC would concur with that.
Thanks, Ian. Okay, we got a question about tax credits. If the borrower receives the tax credits and monetizes them 12 months after the SBA closes and the debenture is sold, and the cash from the sale of those credits are not being used as the equity injection into the project, are there any requirements from the SBA in connection with that?
Well, that's a good question. I haven't seen that, so I'm pausing to think for a minute. Because the borrower will be still leasing the property to another entity, and of course the borrower can't lease 100% of their property to another entity by SBA regulation, I would still recommend that you write it up and get SBA's prior written approval to that transaction prior to the borrower doing that.
Okay. We had a question for you, Bucky. Is the 90-day cancellation of lien instrument requirement going to be included in the interim lender certification?
You know, we have, I think in the interim lender certification, and I'm going to pull it up while I'm talking, but I think we actually say 30 days in that. But let me just look, and I'll see.
There was a related question, now that you mentioned that, asking why 90 days for the recorded releases of interim loan documents when the interim lender certification requires 30 days.
Okay, so it does require 30 days. For a very practical reason, we don't review these loans unless they're at least 90 days old. So we know if we say 30 days in the SOP, and then on the reviews, we're always looking for these things that have been canceled within 30 days. It's going to be a problem on a majority of the cases. So we're giving you the CDCs the 90-day period to get them in. It's just practical.
Okay, thanks. Okay, so we're going to go back to some of the questions that were asked at the first portion where we discussed some of the policy changes. There were some questions about what kinds of things can be included in the rent, in the lease between the EPC and OC. Some of the questions that were sent in were seller financing and other subordinated debt, which you may have just responded.
Which, yeah, that would have been as an existing debt, so that would not be eligible.
Okay. Another question was taxes on rental income and then HOA fees for condo associations.
So as the SOP does cover it, taxes can be included, and HOA to me would be as a maintenance of the property, so that should be included as well. Of course, I always check carefully on these is that you'd want to have the documentation for the HOA, and you want to look at it over to make sure that it is for the maintenance of the building. It's not government fees that they're charging for any other reason.
Okay. If only the project debt is allowed to be accounted for in the rent between the EPC and the OC, how would a new loan from the TPL that SBA subordinated its 504 lien to as part of an approved servicing action be handled?
I'm sorry, but
So this is in regards to the excess rent. So let me just think about this for a second. If only the project.
We're going to have to come back to this question, and we'll provide the answer in the Q&A that we'll issue after these webinars. Some of these will require either additional research or some more expansion on the question. Okay, in the change of ownership, does the OC still need to meet a new public policy goal?
So the way, so if it's a buyout, yes. If we're buying out an existing owner, all loans still need to fit a public policy goal or a community goal.
Well, and one of the reasons why it matters is that you're trying to document job creation. So if it's a buyout, as Bobak's saying, and there's no additional new jobs, then you can't count the job creation without, so therefore you're looking at another public policy goal to make it eligible.
Thank you.
Ian, we got a question asking, what are some examples of waivers that have been approved for prior loss?
Well, actually, we have not seen one lately. I mean, we have not seen one for quite some time.
Okay. The only one that I'm aware of where we've actually had a waiver on prior laws was when HUD had not updated their loan on Cavers, and they decided to do a forgiveness. And the district office had to write us a letter saying that that federal debt had been resolved and that it was no longer considered a prior loss. So that's the only one I'm aware of since I've been here where we had a waiver.
And another question for SLTC, someone wrote in that they find sometimes that Sacramento finds more results than the CDC has found in searching Cavers, and asked whether Sacramento is using a different system and how these screen-outs can be avoided.
No, we use exactly the same system as the CDCs would use. It comes from the same source of information.
And if you find something on NexusLexis that doesn't show up on Cavers, do we have an opportunity to just advise the CDC that they need to go back and expand their local public record search?
I think we would do that. We would recommend that very strongly, yes.
So I think that when the CDC is asking, I think that if we find something that you don't find, we're going to find a way to reach out to you to explain to you you need to expand your search beyond Cavers. There are public websites at the state and local level that can help you to supplement your Cavers search.
Ian, we also got a question asking whether the religious eligibility worksheet can be submitted prior to the application.
We would consider that as a pre-app request, yes.
Okay. Eric, we got a question for you on environmental. Can we utilize a tank closure report to replace the Phase 1 requirement for a gas station?
No, that's because a tank closure report is only going to go as to one particular tank that might be there. There may be other issues. There may have been a prior spill on the property. With a Phase 2, you don't find out about neighboring properties, adjoining properties. That's why Phase 1 is so critically important with gas station loans. It gives us a snapshot of everything going on, not with the station, but also with adjoining properties in the area.
Exactly. A tank closure report doesn't necessarily talk about your well water contamination as well. You have to do testing wells as well. So Eric's right. The tank closure report would not be sufficient.
We also want to see in that Phase 1 report, if you'll recall, something from the environmental engineer that states that the station is in compliance with all state requirements as to the tank's tightness testing, et cetera, if any. So you wouldn't get that with just a Phase 2.
Okay, I think we have some callers queued up. Can we go ahead and take some of those verbal questions?
Yes, we will go to our first question queue. Carl, your line is open.
Hi, this is Carl in Salt Lake City. I just wanted to clarify, and maybe you can clarify it in the Q&A when you send that out. If you've got a 504 project, got the third-party lender and the 504 loan, and that's covered in the lease, and nothing else. But then the borrower or the EPC goes and makes some additional improvements, that with something other than a 504 loan, could even be a 7A loan or something like that. So are you saying that other loan, that the lease cannot be increased to cover the expense of that other loan?
Kieran, do you want to take that question?
Yes, if that is on the subject property, yes. The answer to that is yes.
Then the lease can be increased to cover that additional payment for that new loan?
The OC is utilizing those. If the operating company is utilizing those improvements that the EPC is adding to the project property, I would think that could be reflected in the rent payment.
Okay. Thank you.
And going to the next caller in queue, Julie, please go ahead.
Thank you. So we just want to make sure and clarify, as far as the third-party loan, you're saying that can't be paid down faster? Are we discouraging our borrowers from paying off debt if they have excess cash? We're a little bit confused on that.
No, what we're saying is that you can't use the EPCOC rent as the basis. You can't inflate EPCOC rent for the purpose of paying off your TPL faster. If you have other means outside of the EPCOC rent, you can always pay off your TPL faster. Not only does that make the TPL happy, but it improves the SBA's position. It's just we have to be very strict about what we allow in the EPCOC rent. Would any of the attorneys like to add additional clarification?
And that was our big thing. I guess we just thought it didn't make common sense to not want that debt to be paid off if the borrower happened to have money. It's just, so what you're saying is that you just don't want to see that in increased rent payments. I guess I'm not exactly sure how they get the money from the OC to EPC from an accounting perspective, but
well, what we're saying is that when the borrower is giving you an amount of that EPC rent, and we have on the slide that we're displaying, these are the eligible expenses. You can't add to that additional payments to the TPL as the justification for the additional rent. Also, too, if the calculation of those expenses doesn't reach market rent, and the CPA has said, well, wow, you could go ahead and charge market rent, the borrower may come back to you and say, well, what can I use apply with the excess beyond these items? And you would explain to them, well, in your case, you can't really go up higher than these allowed expenses. So please advise your CPA that you cannot increase your rent to cover costs beyond what SBA allows.
Okay.
And we've specifically stated so that you could share with the borrower and their CPA that accelerated payments to the TPL cannot be added to the EPCOC rent.
Okay, thank you.
Okay, we got another written question asking if heavy mobile equipment is eligible. That actually is a change that came out in the catch-all regulation. So if you search on the Federal Register for the catch-all regulation, you can read in there about the change to the heavy mobile equipment. It was in our previous PowerPoint, but that's where you'll actually find the text.
It's also described in the SOP, and just so you know, for your purposes on today's call, for those who couldn't make the October 23rd webinar, when we talk about heavy mobile equipment, we're not talking about cars that are rolling stock. We're not talking about cars, trucks, all-terrain vehicles, trolleys, things of that nature. We're talking about heavy mobile equipment. We are talking about heavy-duty equipment such as cranes that would have an existing useful remaining life of more than 10 years that you could document through their remaining useful life. Also, too, you would have to explain why they are not considered rolling stock. While some of these types of heavy equipment that may be moved from work site to work site or mobile and can go across the roadways, many of them cannot do it without a custom permit. Even if they have a VIN number, there are restrictions on how this type of equipment can be moved. So that we ask that you provide documentation not only on the remaining useful life and the value, but that you also provide documentation to the center to document that it's not a standard vehicle. Even if it has a VIN number, there may be reasons that it's not considered rolling stock, but we need you to document that.
And there are some examples that will come out in the Q&A. Lauren, I think I saw one more hand in the queue. I think we have time for just this last question, and then we'll have to call it a day.
All right, Janice, your line is open.
Hi, this is Jan Garlitz. On slide 6, you talk about direct expenses of holding the property, such as routine maintenance. Is the EPC setting up a reserve for repair and replacement? For example, for putting a new roof on a warehouse, would that be considered a direct expense since you're referring to it as such as routine maintenance?
Jan, I think capital expenses and property maintenance reserves within reason are certainly eligible, but the center will look at that if it is a reserve, and they may question reasonableness. I know of an example of a case where we had someone who was requesting $800,000 excessive rent, and so that's the type of scenario that would make us go back and question how reasonable is the reserve. But if it is a reasonable reserve and that can be documented, we would ask once again for the CDC's cooperation in giving us the kind of documentation that would assist the center in making that assessment. Ian, would you want to add anything to that?
No, I just want to add that, we need supporting documentation such as, the life of the remaining life of the roof or something to show that, the building is going to need a new roof in the next 2 years or 3 years or something, If the remaining of the roof is 15 or 20 years, I don't think we have a good case here to say that. We start collecting the money for the replacement.
Certainly, we always encourage borrowers to be forward-thinking and maintaining the property. That's our collateral. We definitely encourage them to be excellent stewards of their own property, especially when they're utilizing a federal program.
Thank you.
Okay, so any of the questions that we didn't get to today will be reviewed and written up in our Q&A document that we're working on getting out to you guys along with last webinar's questions as soon as we can. Again, the slides will be distributed to all of you and sent to the field offices and NADCO. And we thank you guys for your time.
We'd like to thank our presenters today from the Office of General Counsel. We have Eric Adams, we have Bill Gary, and we have Bucky Rudisell. They were very informative and very responsive today, and we want to thank them for helping the Office of Financial Assistance with today's webinar. Today with me at headquarters, we have Kim Chide, we have Warren Boyd, and we have Babako Sani. The 504 team is always here to be helpful and responsive. Please let us know how we can assist you further. Thank you.
Thank you to all our speakers and participants for joining today's call. This event has concluded, and you may now disconnect.